Good morning, Ms. Banish.
Good morning, Your Honor. May it please the Court, I am Teresa Banash, and I represent the plaintiff, Frederick Pellegrini, who is the administrator of the estate of William Bruinsma. Ruth Hobden, the previous executor, recently died, and Mr. Pellegrini was substituted as the administrator. This is a case where we are trying to reform a will on an equitable basis to create a charitable remainder annuity trust in order to carry out Mr. Bruinsma's charitable intention of and his estate plan of giving a very substantial amount of his lifetime's earnings to two charities, the American Heart Association and the American Cancer Society.
Now, are you asking us to reverse Flannery versus McNamara?
No, Your Honor, we are not asking.
And why did you not cite Flannery versus McNamara in your brief, since in that case we said that we don't reform wills?
Because I made a mistake in not distinguishing that case, and it is distinguishable because in that case they were trying to reform the will in order to change the beneficiaries of the will. They were using extrinsic evidence of the decedent's intent, stating that there were two friends of the family that he really meant to give his estate to. Well, and we're not attempting to do that. We're not attempting to change any of the beneficiaries at all. We are simply trying to reform the will, as has been done in many trust cases.
But Ms. Banash, A, you are using extrinsic evidence, and B, you may not be changing the beneficiaries, but you are seeking to change the amount that they would get, because the 5% is, I take it, less than they would get if the will had been just the way that it was written, because they would have gotten 50% of all the from all the stocks and bonds or whatever else he had. So it is less, or certainly a different amount than he had contemplated providing for the two income beneficiaries or lifetime beneficiaries.
Yes, it is, Your Honor. It is a different amount, but it's consistent with cases where trusts have been reformed, where there is one case, Siegel, I have right here, Siegel versus Miller, in which there was a trust, and the trust provided for the net income to be paid to the beneficiary. Actually, the trust provided for 10% of the income to be paid to the beneficiaries each year. But when that turned out to be disadvantageous to the charities, the court permitted it to be reduced to a lesser figure. In order to comply with the Internal Revenue Code, provision 26 U.S.C. 2055 requires that between 5 and 50%,
Yes.
A definite percentage has to be paid each year. And we are, I think if you, the evidence that we are trying to put in is not extrinsic evidence of his intent, but it complies with the decision in this court of Gray versus McCausland, where this court took evidence regarding how a decedent conducted herself in between the time that her husband died and the time that she died with respect to certain bank accounts. And this court said that it was not taking it to change her intent, but it was taking it, they used the evidence of the decedent's conduct and facts within her knowledge only insofar as it helped to put the reviewing court in her position to show in what sense she used certain words in her will. And what we're saying...
Did that reform a will, that case?
It construed certain language in the will.
But you're seeking to reform this will. I mean, you're totally changing this will.
There are indicia in the present will that conform to the requirements of the Internal Revenue Code, in the sense that the money is being held by fiduciaries each year. It is there's a provision that the annual income must be paid to the beneficiaries, and then the balance is being given outright to two charities. That is virtually what the IRS code requires. It's just that the language was not prepared correctly.
May I ask you about that? My sense is you're really saying, look, he withheld information from his lawyers, and if he had been forthcoming, the lawyers would have drafted the will a different way. Isn't that, if I boil it down, what your position is? And so aren't you saying to us, so we should factor in that he withheld this information, and we should insert in the information that he withheld in order to accomplish what you want us to do? And if we do that and you prevail, let's just say we were persuaded, then won't we be inundated by other beneficiaries who say, well, this person also withheld information? Don't we have to have bright lines on things like wills?
Your Honor, there is a case which is virtually identical to this case, which is Ratchin versus Ratchin, where this court did change a trust under identical circumstances. It was an elderly man who went to an attorney to have an estate plan prepared. He, like Mr. Bruinsma, was very, very frugal and lived a very Spartan life, but wanted to give the balance of his assets to charity. And when he went to see the attorney, he understated the value of his income of his assets by 50%. I went back through the probate court and through the briefs in that case, and he told his attorney that his assets were worth $900,000 when in fact they were worth over $2 million. And based on that mistake and that miscommunication with his attorney, this court did reform a trust and into a charitable remainder annuity trust, which is exactly what we are asking to do here.
But at least the trust was in the will. This will has zero trust.
There's no question, Your Honor, and I believe that there's a very long history of cases which say that wills can be interpreted to give effect to the intent of the testator.
What if how do we know that, though? I mean, what if the intent of the testator was, I really don't care. All I know is I don't want to pay more legal fees. I mean, that seems to be the thrust of the affidavits. I don't want to pay more legal fees to have some fancy-dancy trust in my will, and therefore, I'm not going to tell you much, and all I want. Didn't he come in and say, I want a simple will, draft me a simple will?
He did, Your Honor, and I think the problem arises from Attorney Peck, because if you'll notice, Mr. Peck's affidavit does not state that he discussed any federal estate taxes with Mr. Bruinsma. So as an elderly man, I think we're assuming that Mr. Bruinsma would have considered estate taxes. I think it's the attorney who is preparing an estate that should disclose to his client the potential consequences of not disclosing the full amount.
Aren't you really making a malpractice claim that these charities can bring against Peck?
Truthfully, Your Honor, if we could have made that claim, we would have done that, but the statute of limitations has expired for making a claim against Attorney Peck.
Now, in the last 12 years, what is the legal status of this money which is going to the beneficiaries?
It's been paid, the income has been paid 50% annually to each of the beneficiaries. Ruth Hobden died last year, so now the 100% will be paid to Lucy Breitenbach.
And was there any testamentary trust that was created, and any taxation as a testamentary trust? No.
No, that's the problem.
Have the estate taxes been paid?
No, they have not.
12 years and they haven't been paid?
That's correct. That there is the problem is that Attorney Peck gave Ruth Hobden absolutely no assistance, told her to go and pay the income, and after Attorney Turner in my office was retained to prepare a will for her, he realized what happened and has then gathered all the assets. The problem was, once we decided to try to reform this will, how do you pay the taxes? Because it's inconsistent to pay them to pay an estate tax, but to claim that the will should be reformed. And that's the reason that we are here. There was a significant delay in finding Mr. Collins, in getting a sense from the charities, and also a very significant delay in getting an affidavit from Attorney Pack, which court has requested when an attorney's mistake is involved.
Now, in Flannery versus McNamara, 2000, we cite Sanderson versus Norcross, an older case, and we write, courts have no power to reform wills. Hypothetical or imaginary mistakes of testators cannot be corrected. Omissions cannot be supplied. Language cannot be modified to meet unforeseen changes in conditions. The only means for ascertaining the intent of the testator are the words written and the acts done by him. How do we do what you ask without effectively undoing Flannery versus McNamara?
Again, Your Honor, the way that we distinguish that case is that in Flannery versus...
You never cited the case, Flannery versus McNamara. It's not in your brief, is it?
No, it's not, Your Honor.
I mean, you're asking us essentially to undo a 2000 case which says we don't reform wills, and you don't even include the case in your brief. Why is that? Why do you...
It was an error on my part, Your Honor. It was an error. I have done... That brief was filed a while ago. I've continued to do legal research, and I realized that was a significant issue. And my response to that is that in Siegel versus Miller, this court did reform a will and a trust in a will to permit the estate to take the largest marital deduction possible for estate tax purposes. And there's no question that what we're asking has not been done before.
Now, Siegel versus Miller is not in your brief either.
Your Honor, I am admitting I made a mistake in not discussing those cases, but I'm here to answer the issue at the present.
What do we do with regard to the statute of wills, which says Chapter 191, Section 1A, subsection 2, the intention of a testator as expressed in his will shall control the legal effect of his dispositions?
His dispositions do not change. They still go to the income beneficiaries and to the charities. The difference is that by creating this trust, we are able to minimize the estate taxes to zero and maximize the amount of the assets that will be given to the charities.
Okay, and that's based on the expectation that since he was frugal, he would not have wanted any money to go to the federal tax authorities.
Dennis Collins and Ruth Hobden, in their affidavits, stated that he didn't like the IRS and that he felt that the government was rich enough and didn't need any more of his money. That is the best evidence that we have. The overwhelming evidence, Your Honor, is that he lived a very frugal but kind and generous life. He wasn't like Ebenezer Scrooge. He was kind to other people, and he amassed this very significant amount of money with the intent of giving it to charity. All we are trying to do is maximize the amount of the money that is ultimately payable to the charities.
All right. Now, and following up on Justice Ireland's question, if we do what you asked us to do, does that mean that any time a will has been less than perfectly effective in terms of maximizing its tax avoidance, that the person can come to this court and seek to maximize the tax avoidance of a will?
I think in a very narrowly defined set of circumstances, that decision could be rendered. And there are many cases where the words of a will have been construed in such a way to get the maximum tax benefit.
Ms. Van Ash, what is your best will case? Not trust reformation case, will case. Which case do you say, if you were to do this, it's not a radical change in the law because in this case, which involved an interpretation of a will, there was a broad construction, whatever it is that you're asking us to do?
I guess the best case would have to be the Siegel versus Miller case, because it did discuss...
Could you give me the citation to that,
Yes,
please?
it's 443 Mass 1007, it's 2005. And that would be because it did, it reformed the will and the trust where there was a conflict between the provisions in order to permit the estate to take the maximum marital deduction that it could take.
Thank you, Ms. Benet.
Thank you.
Good morning, Ms. Constantiz.
Please, the court,